Constitutional Law 2, lecture number 2, Amendment of the Indian Constitution. Previously, I have delivered first lecture from Constitutional Law on Judicial Review. In later, I will take up Central-State Relations, Services and other parliamentary privileges and other important topics from the examination point of view. This is my 179th lecture from out of 18 subjects. Out of these 178, around 150 lectures I delivered in English language. Nearly 28 lectures I delivered in Telugu medium for the benefit of my students in Andhra Pradesh and Telangana, India. Today I will take up this most important topic from examination point of view, amendment of the Indian Constitution. In this lecture I will cover introduction, that is the need and necessity of amendment acts, that is making amendments to Constitution. Secondly, the number of articles, parts and schedules of Indian Constitution at the time when it came into force, and now how many articles, parts and schedules it contains as on today. But what are the ways in which amending process can be taken up by the Parliament? What are what is the procedure for amendment, and whether Parliament can amend fundamental rights of the Constitution, whether Parliament can amend preamble of the Constitution, and case law is what I am going to discuss in this lecture. Before going to take up my lecture, I take just 1 minute to pray God, to salute the state of Andhra Pradesh for my birth and brought up, the state of great Maharashtra for my growth and development. I pay homage to my reverend parents, late Rega Apparao and late Srimati Kantaratnam, and my beloved wife, Mrs. Balivada Rega Tirumala Gauri, advocate, and my co-author for my academics. I express my gratitude to all the godfathers and publishers who are instrumental for what I am now. I express my heartfelt thanks to the authors of textbooks and research papers and articles in internet, whose works I have taken for uploading this, whose publication I made use of for making this lecture. And finally, above all, it is my duty to express my deep sense of gratitude to my student friends who are solely instrumental for what I am now, dear friends. So, as you know, I am Principal Retired Aided Law College, Maharashtra, India. Today, I wish to cover this Constitutional Law 2, second lecture, amendment of the Indian Constitution. This topic is, as a matter of fact, a burning topic. Many hours can be discussed. Even one case can be explained hours together. But you are in first year of the LLB, in early stage, I will give you a spoon feeding to the best of my ability and knowledge. Firstly, let us now discuss about introduction. Law and society are causally connected and interchangeable. Law and society regulate each other. Law is an instrument that regulates human conduct in a society. In simple words, law regulates the behavior of the people in the society. That is why we can say that there is a causal connection and relationship, special relationship between law and society. Law and society. So that is why the law has to be changed. Law gets changed in consonance with the changing conditions in the society, social, economic, political and cultural. So in India, our Indian Constitution was passed in the year 1950 and it came into force on 26th January 1950, that is after our independence. Before our constitution came into force in the year 1950, 90 years earlier, that is in 1960 onwards, so many legislations were passed. During the British regime, during British rule, that is during Third Law Commission period, 19 legislations were passed, namely Indian Penal Code 1860, Criminal Procedure Code 1861. Subsequently, it is recodified as 1898 and then finally Criminal Procedure Code 1973. But Criminal Procedure Code got recodified several times, but the Indian Penal Code, which was passed in the year 1860, remained unrecodified and some criminal law amendments were made. So today we call Indian Penal Code 1860 because it is not revised. Indian Companies Act 1956 was recodified in the year 2013. Similarly, Consumer Protection Act, which was originally passed in the year 1986, was recodified in 2019. So here, this is the question. So Indian Constitution came into force in 1950. Several legislations were passed 90 years earlier, that is during Third Law Commission period, that is Indian Penal Code, Indian Evidence Act, Criminal Procedure Code, Specific Relief Act, Sale of Goods Act 1930, like that. So many, Transfer of Property Act 1882, Easements Act 1882, like this. So whether any law passed before the passing of Indian Constitution or after the passing of Indian Constitution must be according to the provisions of the Indian Constitution. So the constitutional law is law of the laws. Constitutional law is a supreme law of the land. So any law on the territory of India must be according to the provisions of the Constitution. So this is the Indian Constitution. Constitutional law is law of the land, supreme law of the land, national law and leader of the laws and the law of the laws. So here this Constitution came into force in the year 1950. The provisions of the Constitution were so designed by the drafting committee under the favorable auspices of Dr. B.R. Ambedkar ji with this in association of B.N. Rao ji. Our Indian Constitution was drafted taking into consideration the socio-economic conditions prevailing at that time. So as the time passed, so many changes in the society take place: social, economic, political and cultural. So in consonance with the changing conditions, law has to be changed. Constitution has to be changed, provisions of Constitution has to be changed and other provisions also have to be changed. For example, when I was studying 10th standard, and intermediate, that is in 72, 74, like that, there was no Xerox. One has to get typed and attested by the Gazette officer. Gazette officer was very inconvenient to verify all these things. Today we have Xerox. Then in those days there was no wireless. Today wireless was available even in a topmost official, district collector, SP, like that. Today cell phone is available even even a poor man, even a servant maid also maintaining cell phone. So the socio-economic conditions are change from time to time, place to place, situation to situation. That is why law has to be changed according to the changing circumstances. For example, out of the human rights, most important human rights are listed in fundamental rights. Comparatively less important human rights are placed in directive principles of state policy. As the time passes, what are comparatively less important enshrined in directive principles of state policy have been deleted from directive principles and included in fundamental rights. For example, right to education was earlier in directive principles of state policy. Subsequently, it is included under Article 21 as one of the topic in Article 21. Subsequently, a constitutional amendment was made, and right to education was given independent status as a fundamental right. These things I explained in detail in previous subject, that is constitutional law 1. So that is why, as the time pass, so many socio-economic changes, political changes take place. According to changes, law should be changed. In case of some legislations, amendments are made from time to time. In certain cases, the law as a whole was codified. For example, Companies Act was recodified, criminal procedure code got recodified, civil procedure code remain uncodified, 1908. So when opportunity comes, these legislations are recodified, but some legislations remain uncodified. Only amendment acts are taking place. So here, Indian Constitution, which came into force on 26 January 1950, is getting changed through amendment acts, and it remain it has not yet been recodified. So, as strictly speaking, there are 105 amendment acts. So, our Indian Constitution also has to be recodified, like India Companies Act or Consumer Protection Act, like this. So here, this is the position. So when our Indian Constitution came into force, it consisted of 395 articles divided into 22 parts and 8 schedules. That is in 1950, when Indian Constitution originally drafted, it contained 395 articles, 22 parts, and so part 1 preliminary concepts, preamble, and part 2 citizenship, part 3 fundamental right, part 4 directive principle. Some articles put together comes under 4, just like one chapter contains so many sections. So here, for other legislations, the word section is used. For Indian Constitution, article is used. Some students may put a doubt, raise some doubt. Sir, why Indian Constitution or the provisions of Indian Constitutions are entitled as articles, and the Constitution's other enactments are entitled as sections? Because there is some special supreme, Indian Constitution is the supreme, its provisions are supreme. So all the provisions of Indian Constitutions are independent, whereas the provisions of any legislation, central legislation, they must be according to Indian Constitution. So any state legislation, the provisions of state legislation must be according to central legislation, that is parliament and this thing. So that is why it is in some superior authority, the legislation, the constitution is supreme law of the land. So its contents or provisions are entitled as articles for the reason they are supreme and independently independent and not interrelated. So whereas in a United Nations conference, so many conferences take place on various issues, law of the sea or environmental degradation, hijacking, airspace, outer space, like that. In those international conferences, any declarations are made, any covenants are made, they contain, these rules are called articles only. So because that the word article confers some special status or supreme status, that is why, for example, school head, headmaster, college head, principal, like that. Like that we are calling school teacher, lecturer, professor. But nowadays in modern world, in university, teacher is called, instead of professor, he is called teacher. London School of Economics and Delhi Law School, the School of Law, Delhi University, National Law School of India University. The words of university, college, very differently used irrespective of that. So that is why this word article denotes something special or superior. So this is the position. But at the time, after 99 amendment in 2014, there were about 500 articles, 25 parts and 12 schedules. But whatever the number of articles may be, the first article is article number 1, last article is article number 395. But the extra articles, some articles are deleted, some articles are added, A, B, C, D, E, like that they will come. So by constitutional amendments. So next one is, as on 6th March 2022, in Indian Constitution, preamble is there, 465 articles are there, divided into 25 parts and 12 schedules. 12 schedules in the sense, so many acts, some schedules are there. The schedules contain some tables or forms or the prescribed forms or lists. But in our Indian Constitution, some schedules are there. Suppose some subjects are there, state list, some subjects are dealt by union government, some subjects are dealt by state government, some subjects are dealt by both central and union government. So in criminal procedure code, schedules are there. Schedule contains different tables. What are the cognizable offences? Non-cognizable offences. Bailable offences? Non-bailable offences. Schedule to prescribe pro forma. How the bail application will be there? How the charge? What is the pro forma for charge sheet pro forma? Bail application pro forma, or different summons procedure. All the prescribed pro formas are there. They are available in the schedule. So some acts, only acts are there, only sections are there, article. For some enactment, schedules will be there, and schedules also will be there. This is the position with reference to introductory part. Now, in India, Indian Constitution came into force in 1950. As per the changing conditions in the society, Indian Constitution amended from time to time. So, for passing law, procedure is same. For Amendment Act also, procedure is same. For passing law, procedure is same. For passing Amendment Act also, procedure is same. So that when any law is to be, new law is to be drafted, to be codified, or old law is to be recodified, or instead of any Amendment Act is to be codified. Sometimes suppose the law of torts is not codified. If it is codified, specially a committee, it is referred to law commission will prepare a bill, and the bill is presented to the Ministry of Home Affairs. The concerned ministry will present finalize it, and it will be sent to the Lok Sabha, then Rajya Sabha, and President assent, and it once come back, it is published in Gazette for Gazette notification. Then that law will come into force. So for making fresh law, or recodifying the law, just like Company Act. Indian Companies Act 1956, for it is recodified in the year 2013. For that, the procedure is same. Instead of company law, subsequently the Amendment Acts have come into force. For Company Law Amendment Act also, procedure is same. For original codification, recodification, or making Amendment Act, the procedure is the same. Then the concerned ministry will prepare a bill with the made by the law commission, propose that to law commission. Law commission will prepare the bill, appointing chairman and member. It will come to the concerned ministry. It will go to the Ministry of Home Affairs. It will present it in Lok Sabha or Rajya Sabha, and then after majority, it will go to presidential action. After returning from presidential action, it will be published in Gazette notification. Then only that law will come into force. When to apply, where to apply, what are the provisions will come into force immediately, what are the provisions will come into force later, which remain pending, what areas these laws are applicable, what areas is not applicable. All these issues are mentioned in the Gazette notification. So this is the position. So now, so far in India, we have 105 amendments. First constitutional amendment was made in the year 1951. 1950 constitution was passed. First amendment took place in 1951 regarding the power of parliament to amend constitution unlimitedly, limitedly. That constitution first amendment speaks about unlimited power of constitution. These aspects we will take. And latest amendment is 105. 104 Amendment Act number 104 was came into force on 10th December 2019. This Amendment Act 104 Amendment Act, Constitution Amendment Act, the Constitution 104 Amendment Act 2019, which came into force on 10th December 2019, refers to extension of reservation to members of scheduled caste and scheduled tribe in state legislatures and central legislature parliament. When Indian constitution came into force in 1950, these reservations are provided under protective discrimination as envisaged under section 15, article 15.4, reservation in education and institution, 16.4, reservations to socially and economically backward SC/STs in employment. Like that, similar reservation is given to members of state legislatures and central legislature parliament. Every 10 years, when reservation is given, its maximum lifetime is 10 years, but every time every government is extending accordingly. From so far 70 years, we got constitution 70 years back, 1950. Since then to 2020, 70 years it is being extended, and now from 70 years to 80 years, this constitution is being this reservation is being extended to members of the state and central legislatures. And 105 with reference to open category, conferring power on states and union territories to determine socially and economically backward caste people for open OBC, open backward community. This is 105. It took place in the 105. It came into force on 15th August 2021. So in India, we have so far 105 amendment acts. We have, as on today, that is 6th March 2022, we have in Indian Constitution content Preamble 165 articles divided into 25 parts and 12 schedules. This is the introductory background of this Indian Constitution. So, amendment of the Constitution, Article 368 of the Indian Constitution confers power on the Parliament of India to amend the Constitution. To amend the Constitution means the constitutional provisions remain intact. So problems will take place. problems will take place. So as per the changing conditions in the society, the rules are to be changed according to the circumstances. For example, we go to Tirupati temple, time to time rules are changed according to the circumstances only. So like that, any company, anywhere, in a school, college, anything, the rules get changed from time to time depending upon the changes in the circumstances. Because we cannot strictly adhere to follow the rules which were drafted long back. That is why the changes need change from time to time. So that is why the Constitution of Article 368 of Indian Constitution confers power on the Parliament, that is Central Legislature, consisting of Lok Sabha and Rajya Sabha, headed by the President of India, power to amend the Constitution. So here, with the power of the amending Constitution, the Indian Parliament, through constitutional amendment acts, can change any provision, any chapter as a whole, any clause or subclause as a whole. It can alter the provision, it can delete the provision, it can add the new provisions also. So that is why in Constitution Second Amendment, the word secular is added to Preamble. So similarly, so many changes take place. And the Article 19(1)(f) is deleted, Article 31 is deleted. When the government needs some land of an individual for public purpose, then that individual cannot claim. Earlier, right to property was a fundamental right. Now it is deleted. If the property of an individual is needed by the state for public purpose, for widening roads or widening roads or constructing highways or to constructing railroads, individual cannot say that right to property is my property like that. All these issues I explained in detail in Constitution Law 1, dear friend. So by amending power, the Parliament can delete, alter any part of the Constitution, delete any part of the Constitution, add any article, number of articles, chapters as a whole it can add, chapter as a whole it can delete, chapter as a whole it can add also. Such power to alter, delete or add new articles by passing amendment acts. So to make fresh law or to make or to recodify any particular branch of law, including Constitution, or to pass any amendment act, either in respect of other legislation, central or state legislation, in central legislation, state legislations, making any amendment acts for making constitutional amendment act. The procedure is same. The bill is to be presented in Lok Sabha, Rajya Sabha, and then presidential assent, followed by gazette notification is the general law. So, what are the kinds or ways? So, Indian Constitution is written Constitution. Indian Constitution is the written Constitution. Secondly, the nature of Constitution may be rigid or flexible. Rigid means the constitutional provisions cannot be amended so easily. For example, American Constitution. In American Constitution, the number of articles are very few and the amending process is very, very difficult. So, Indian Constitution is rigid and flexible. Some provisions of the Constitution can be amended by simple majority by presenting ordinary bill. Some change of certain constitutional provisions, the amending process is rigid or difficult. So what are they? There are three categories, three kinds of amending process. So the Parliament of India can amend the constitutional provisions in order to change amend the constitutional provision to pass Amendment Act. Three procedures are there. First procedure is simple majority. So how many members are there in the present? The bill to make changes in some ordinary bill, proposing some changes will be there, and by simple majority, even 50-51. If 51 votes are there, 51% votes are there, that is called simple majority. Second one is, there are some articles. For simple majority, Article 5, citizenship, Article 9 and 169, creation of legislative councils, Article 239, creation of local legislature and central council of ministers. So, for making to bring about any changes in respect of certain provisions, special majority or special majority plus rigid procedure is not necessary. Simple procedure is there. That is, if any provisions relating to citizenship, any rules are to be changed, any provisions are to be changed, simple majority. So, creation of legislative council. In India, we have 29 states and 9 union territories. 9 union territories, even after Kashmir's issue. And here, some states are having legislative assembly and legislative council. Some states are having only legislative assemblies also. In Andhra Pradesh, from the beginning, for a long time, legislative assembly and legislative council were there. And NTR government time, legislative council was abolished. And again, Rajshekar Reddy, that is the late father of present state chief minister, Jagannath Reddy ji, legislative council is restored. Now legislative council is there in Andhra Pradesh. So, with reference to any changes in a council of minister and creation of legislative council, and so under Article 169 or 239 of Indian Constitution, these provisions can be amended by simple majority. Secondly, a special majority. Special majority means the bill is presented by the concerned ministry and the law. And when the bill is presented in Lok Sabha by the concerned ministry, and it is tabled before Lok Sabha or Rajya Sabha, when it is presented first in sometimes generally the bill is presented in Lok Sabha, the amendment bill, and thereafter, after approval in Lok Sabha, it will be sent to Rajya Sabha and then President. So here, when it is presented in Lok Sabha, Rajya Sabha, the number of members must be present is not less than 50% members of the members must be present. For example, Lok Sabha, there are around 540 members, and to 50% means 270 members must be present. Out of the members present 270 and above, it is to be approved by two-third majority. For example, two-third majority. So more than 2. Suppose out of 300 present, for example, 200 must vote in favor of that. That is two-third majority. Two-third majority. When it is approved by Lok Sabha, then the bill will be sent to Rajya Sabha per proposal. There also not less than 50% members must be present. Two-third must vote in favor of that. And this should be approved by Lok Sabha and Rajya Sabha. If there is any disagreement, there cannot be any joint session, and the bill after approval from Lok Sabha and Rajya Sabha, it will go to President for assent. And the assent of the President is just formal. Whenever a bill is approved by both Lok Sabha and Rajya Sabha, a President will give his approval by giving his assent. Then that bill will come back to the Ministry of Home Affairs. After some time, it will be published in Gazette notification. Suppose even after a presidential assent, the bill may remain unpublished for 1 year and above. 1 year and above. The Consumer Protection Bill after assent from President of India was not 2019 Consumer Protection Act was not published by Gazette. It was published on 20th July 2020, and later so some provisions came into force immediately. Central Regulatory Authority came into force on 24th July, and the different dates also are there. So simple majority is one process for passing Amendment Act. Special majority is one process, special majority. Third issue is for special majority, election of president and election of president is there, and election of president, Article 55, Article 124 to 147 are relevant provision which need special majority. Please, 50% of the members must be present, out of which 2/3 members must vote in favor of that bill. So 50% present plus 2/3 majority. That process is called amendment, process of amendment by special majority. In certain cases, center-state issues relating to both center and state and high courts, Supreme Court issues, judicial review, separation of power, and representation of states in parliament, the 7th schedule, article amending power of the constitution under article 378. Such crucial issues, after approval by Lok Sabha and Rajya Sabha with 2/3 majority, the bill will go to state legislatures. More than 50% of the state legislatures must approve it. That is called ratification. Suppose a agent has done an act, if a principal has to agree for that, accepts it letter, that process is called ratification. So here, the process of amendment in India, there are three categories, three ways. First one is passing of Amendment Act by simple majority, amending process by special majority, 2/3 majority of Lok Sabha, Rajya Sabha and presidential assent. Third procedure is 2/3 majority in Lok Sabha, Rajya Sabha and ratification by more than 50% of the state legislatures, and then it will come back and then go to presidential assent. After that, after getting presidential assent, this bill will be published in Gazette notification. After Gazette notification only, the courts can apply by interpreting that particular law, whether it is constitution or any central legislation. This is the position. These are the three kinds: so simple majority, special majority, and these are the procedures. Next point for discussion is whether Parliament can amend Part 3 of the Indian Constitution. Part 3 of the Indian Constitution. So I told you, as on today, there are 25 parts. Part 1 deal with preliminary accept, Part 2 citizenship, Part 3 fundamental rights, Part 4 directive principles of state policy, and Part 20, Article 368 deal with this. Some parts contain so many articles, certain parts contain only one article only. For example, Part 4A, fundamental duties, contains only one article, Article 51A. Like that. So here, whether Parliament can, whether the Parliament of India, by exercising its power of amendment under Article 368, can Parliament amend the provisions of fundamental right. In Constitutional Law 1, I told you, Article 12 to Part 3 containing Article 12 to 51 of the Indian Constitution lay down various provisions relating to fundamental rights. Article 32, I think. Article 32. There are various provisions relating to Part 3 of Indian Constitution contain various provisions relating to fundamental rights. So these fundamental rights, Article 12 deals with state, 13 speaks about law, 14 equality, 19 freedom, so 25 to 28 freedom of religion, like that. So many Article 29, 30, this 29, 30 minority rights, 31 2, these are all fundamental rights. Thereafter, directive principle. Part 4 contains directive principles from thereafterwards. Now coming to the point, whether Indian Constitution, whether Parliament can amend fundamental right of the Indian Constitution. Fundamental rights, among human rights, fundamental rights are most important rights. Most important rights, which rights are very inherent. Without fundamental right, no human being can survive. That is, freedom of speech, expression, right to livelihood. All these things I explained in fundamental rights chapters so many times, and there is no time to explain all these things once again. So fundamental rights, human rights are basically two categories. The human rights of topmost importance are enlisted in fundamental rights. Human rights of less importance are enlisted in directive principles. As time passes, some directive principles are also included in fundamental rights. Now the question is, the Indian Constitution, through its preambular slogan, ensured the people of India to provide fundamental rights. The Supreme Court of India is the custodian of fundamental rights. If any either by executive action or legislative action, if a fundamental right of an individual is affected, he can directly approach the Supreme Court for protection of the fundamental rights. So the framers of Constitution, while providing Article 368 conferring power on Parliament to amend the Constitution, they did not put any restrictions. So that the Parliament has power, they said. What is the extent of power? They did not say. So that is why Indian Constitution is rigid and flexible. So that is why, to what extent the Parliament has power, they did not define specifically. So that is why there are two views. The Parliament can exercise unlimited power to amend any part of the Constitution is one view. Second view is Parliament has limited power. It cannot exercise unlimited power is second view. So the first time the constitutional validity of First Amendment Act was challenged in the year 1951 in Sankari Prasad versus Union of India. Sankari Prasad versus Union of India, the constitutional validity of First Amendment Act was passed. According to this First Amendment, it is said that amendment is not law according to Article 13 of the Indian Constitution. Article 13 of the according to Article 13 of Indian Constitution, Article 13 speaks about law. So according to Article 13, any rule, regulation passed by executive, legislature, not only executive, so laws means general laws, rule, regulation, custom, tradition, precedent, all rules, regulations, whether by executive or anything, they come within the meaning of principles of natural justice also, including a custom, come within the meaning of law. And second clause is any rule, provision passed by the legislature. So the rules under the various sections under codified laws are enforceable. They are laws. Not only the rules, regulations or provision in a codified law, also law, and general principles, customary principle, or principles of justice, equity and good conscience. Any rule passed by the executive, those things also come under law. So rules passed by legislature are more powerful and enforceable. They are also law. The general principles of justice, equity also, custom also come under the law. But in this Constitution First Amendment Act, which was passed in 1951, tells that in Sankari Prasad versus Union of India, tells that this constitutional amendment is valid, and it's valid because amendment is not law. The Parliament can amend to any extent. That is the position. So This in this case, the facts and all these things I won't be able to tell because you have to read the facts, because it will take a lot of time. So I have to complete all this lecture in this particular only. That is Sakri Prasad versus power of parliament is unlimited. The same view was followed by Supreme Court in Shahjahan Singh versus State of Rajasthan. This is also said that Parliament can amend article. Parliament can amend. So this amendment is null law under Article 30. But these decisions given by Sakri Prasad versus Union of India and Shahjahan Singh versus State of Rajasthan, All India Supreme Court 1965 were reversed by the Supreme Court in Golaknath versus State of Punjab. Golaknath versus State of Punjab. What happened in this case? The validity of Constitution 17th Amendment Act was challenged. So this Golaknath case said that no amendment. We cannot say that amendment is not law. Amendment is also law. So the Parliament by its amending power cannot amend the fundamental right. This is the position. So Sakri Prasad case, Shahjahan Singh's case, Supreme Court said that the power of the Parliament is unlimited. But reversing these two judgments, quashing the validity of 17th Amendment in Golaknath versus State of Bihar or Punjab, should be remembered. The Golaknath case, the amendment, these two amendments were deleted. The Supreme Court's decision in Sakri Prasad and Shahjahan Singh were overruled in Golaknath case. In order to overrule the Golaknath decision and make power of the Parliament unlimited, so many amendments were made. So our Amendment Act, Constitution of 24 Amendment was there, 25th Amendment was there, 27th Amendment was there, 39 and subsequent amendments were to 39 Amendment. So many amendments took place in order to confer unlimited power of the Parliament to amend the Constitution. These are the things. So here, according to this, the Constitution, according to Shahjahan Singh, Sakri Prasad, Parliament has unlimited power to amend the Constitution. Golaknath, it is said, Supreme Court said that Parliament's power is limited. It cannot amend unlimitedly and reverse the decision of previous cases. In order to nullify the Golaknath case and subsequent amendments were made, 24, 25, 27 and some other amendments acts were passed. Now here, this is with reference to whether Parliament can amend Part 3 of the Constitution, that is fundamental. In simple word, up to here, the Parliament has unlimited power to amend any part of the Constitution, including fundamental rights. That is the position. Secondly, next one is whether the Parliament with its unlimited power can amend any part of the Constitution. Okay. Now, what is the position of Preamble, which the Indian Constitution stands on 4 founding pillars: justice, liberty, equality and fraternity. And the Preamble slogan is, we the people of India having resolved to ensure ensure all citizens sovereign, socialist, secure, democratic republic. These are all features of basic structure, the ideals and goals to be achieved through Constitution, and these are the founding pillars, basic nodules without which the Constitution cannot function. The main function of Constitution is to uplift the ideals and goals ensured through its preamble. So now the question is, the preamble is most important text it is the index of the constitution. Now the question is whether Parliament, by its power of amendment under Article 368, can amend any part of the constitution. So preamble is just like a preface to a particular subject. Suppose an author writes one textbook. In preamble I explained in detail constitutional law, and you can see. So in preamble, now the question is whether preamble is part of the constitution or not. Some said preamble is part of the constitution, some said it is not part of the constitution. In Berry case, Supreme Court said that preamble is not a part of the constitution and preamble cannot be amended. Preamble is not a part of the constitution. Preamble cannot be amended. This is the Supreme Court made it clear in Berry case. So here in preamble, we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. What is the important significance? I explained in preamble lecture. You just go through it. And ensure justice, liberty, equality and fraternity. 4 pillars. Justice, liberty, equality, fraternity. These are the 4 pillars of the constitution, without which the constitution cannot be. So such a great conscience of conscience ideals are enshrined in the preamble. So whether preamble is part of the constitution, preamble can be amended. If preamble is not part of the constitution, preamble cannot be amended. That is the question. So here in Berry case, Supreme Court said that preamble is not part of the constitution. Any area, any part of the preamble cannot be amended by the Parliament by exercising its power under Article 368. But in Kesavananda Bharati versus State of Kerala, popularly known as fundamental rights case, there was a constitutional bench comprising 13 judges, 7:6 majority opinion, 7-6 dissenting opinion. It was said that the Parliament, the preamble also is a part of the constitution. Any part of the constitution including preamble can be amended, subject to the condition that the basic structure of the constitution cannot be amended. So in Kesavananda Bharati is a very well-known case. The Kesavananda Bharati is a leader of some charitable trust at Nirmat, and there was some question. He challenged the there was the state government passed an act encouraging his freedom of religion under Article 25-26, property guaranteed under Article 19(1)(f) and Article 31, and so many issues are there, and he challenged the validity of that act. And this Kesavananda Bharati versus State of Kerala is a very, very popular act. There is a very big judgment. You read over each and every word of this subject in this particular case. This case appears in so many chapters. So this is very important. So in this particular case, in Kesavananda Bharati versus State of Kerala, the Supreme Court by 6:7 majority rule said that the Parliament, Indian Parliament, by its power of amending power under Article 368 can amend any part of the Indian Constitution, including preamble. However, the basic structure of the Constitution cannot be touched, cannot be curtailed. So, any part of the human body can be taken except a heart or brain. That is the question. Like that. So, this situation to some say that heart is important, then brain is important. Somebody tells that eyes are important. Eyes is entered in basic structure. Somebody dancer tells that hands and legs are important. Then that legs are introduced as basic structure. Somebody tells that tongue is important for singer. Tongue is entered. Like that, one item is added. By the time Kesavananda Bharati case, the Supreme Court did not said that any part of the constitution provision can be amended, including preamble, but basic structure of the constitution should not be affected. Supreme Court said the basic structure should not be affected. What is basic structure? The Supreme Court did not say, but it gave some list of 13 items. 13 items, Republican, Democratic and Democratic form of government. These two are there in sovereign, socialist, secular, democratic. These two are. Secular is there, in the preamble it is there. Supremacy of the constitution, separation of powers, and federal character, sovereignty of the state. Like that, 13 items have been 13 items have been included. Similarly, welfare state, and these are so many things. So, at the time of Keswananda Party judgment, 13 items were Supreme Court did not define or prescribe any guidelines for what is the basic structure, what are the items that come within the meaning of basic structure, what are the items that do not come within the meaning of basic structures were not given. 13 items are given, but subsequently some more items have been included in a basic structure. In Indira Nehru Gandhi versus Rajnarayan case, free and fair election, rule of law, judicial review, free and fair election, judicial review have been included. In Indira Nehru versus Rajnarayan, it is a very big case. Mrs. Gandhi in 1971 election indulged in corrupt activities and misuse of power, and the opponent Rajnarayan of Raebareli constituency challenged the election of Mrs. Gandhi, and ultimately Justice Sinha of Allahabad High Court gave daring and dashing judgment, and he visualized the irregularities made by Mrs. Gandhi, and he decided the case against Mrs. Gandhi when she was the Prime Minister of India, and she was disqualified from contesting election for 6 more years, and subsequently on appeal so many developments were made, and emergency was declared. 3 judges were ignoring, outweighing 3 senior most judges. Fourth senior most judge A.N. Ray was elected. So many developments were there in that particular case. So according to that, what are the activities done by Mrs. Gandhi exercising his power relate to denotes legislative supremacy. So we have 3 organs: executive, legislature and judiciary. Judiciary claims that judiciary is the supreme. Judiciary can correct executive action and legislative action. Suppose a chief minister, council of ministers at state level, council of ministers at central level passed any executive order, it is challenged, the Supreme Court can quash it. And if a chief minister, council of ministers headed by chief minister passed an executive action, if it is challenged, state high court can set it aside, declare it void. Similarly, parliament passed any law, and if that particular law is challenged by any individual, Supreme Court can set it aside. So generally, when executive action or legislative action is done, it is ultra vires. It violates the fundamental right or any other. It infringes the rights of a particular class of people. If that individual or group of individuals or institution or organization approach the Supreme Court can declare it unconstitutional or invalid, void, and it can be set aside. So that is how Supreme Court is making challenge. So far as the activities done by political influence made by Mrs. Gandhi denotes legislative supremacy, parliamentary supremacy over judiciary, and ultimately this was set aside in Rajnarayan case. So no, the judicial review and all, so many developments are subsequently. Minerva Mill case also. In Rajnarayan case, Mrs. Gandhi was Rajnarayan case, free and fair election was included in basic structure. Next, free and fair election, and the judicial review was included in basic structure. In Minerva Mills versus Union of India, harmony between fundamental rights and directive principles of state policy also come within the meaning of basic structure. So fundamental rights, directive principle. There are two, whether fundamental rights are superior or directive principles are superior. In a fundamental rights chapter, I told you, in sometimes the fundamental rights will be given importance over directive principles. In sometimes directive principles should be given importance over fundamental rights. Suppose if any directive principle, state action, executive action or legislative action is passed for public interest, it affects fundamental right. If that person approaches this court, and sometimes fundamental right is given importance, sometimes directive principles are important. To maintain harmony between fundamental right and directive principle, as per the circumstances, that is also what is called harmony between fundamental rights and directive principles is included here. And the next one is like that, separation of powers, so independence of judiciary, or so many items have been included in this thing. So as I told you, originally in case 1 on the Bharati case, Supreme Court did not define anything. Supreme Court said Parliament can amend any part of the Constitution including preamble, and it should not touch basic structure. It did not define basic structure. It did not give any guidelines for that. But the Supreme Court in subsequent cases, so many items have been added. Article 14 was added, rule of law was added, Article 21 was added. So many things subsequently, so many items have been added. So similarly, in Article 21, I told you, when Indian Constitution was passed, Article 121, only life and liberty were protected. Life and liberty were protected. This life and liberty protection was given against executive action only. After Maneka Gandhi's case, this protection is available from legislative action also. Subsequently, earlier, only life and liberty. Subsequently, livelihood is added, education is added, so many number of items. Right to die is added, right to education is added, subsequently education is made, subsequent this thing. In Article 2, so many free legal aid, free medical aid, pollution free environment, right to cremation, right to education, so many items, including right to development. So originally 2 items were there in Article 21, subsequently so many articles. Here in a basic structure theory also, there is no any guideline for definition for basic structure. The Parliament can, case 1 on the Bharati, 6:7 majority opinion, 7 majority, 6 dissenting opinion. In dissenting opinion, A.N. Ray was then Chief Justice was there. This is one landmark decision of the Supreme Court, and at that time only 13 items are there. In subsequent cases, so many items are there. Suppose you say that for a human body, what is most important? Heart is important. Then somebody say that brain also, if the heart is there, brain doesn't function, what is your? Brain is important. Somebody says kidney are important. Somebody say lungs are important. Somebody say that eyes are important. Without eyes, what is the use? Singer tells, for me, tongue is more important. Without tongue, I cannot see. So like that, dancer, hands and legs, choreographer. So like this, so according to time and situation to situation, the number of items of the basic structure have been included. If we see that the preamble is also part of the Indian Constitution, any part of the preamble can be amended means there are so many touch-me-not items in preamble. Sovereign sources, secular democratic republic, originally included. Justice, liberty, equality, fraternity, both are founding pillars without which the huge unifies of Indian Constitution cannot stand. So these are the various complications. That is the reason why the Supreme Courts and High Courts are conferred special powers, review powers, discretionary powers to exercise the jurisdiction of their own without taking into consideration the legal provisions or constitutional provision. They give the judgment of their own depending upon the circumstances of the case. Thank you very much for your patient hearing, dear friend. Thanks a lot.